Right, everybody, I'd like to thank His Excellency Rieaz Shaik for joining us now, and I'll give the 15 minutes to you.
I'm sorry about that cough. Mona had almost not got me here. So if I do some sniffing, it's not because, did I almost say that? It's not because of other things, but other than the fact that I'm battling this flu. The second thing I want to say is that it is not nice to have the graveyard shift, because people are all between now and supper thinking about matters. And the third thing I will say, it's very easy to deal with racism. I had this wonderful discussion. It's simple, just don't do it. Just don't do it. Don't do racism, don't tolerate it, and life will be so much better. Ask South Africans about that. I thank the Institute for Peace and Diplomacy for convening once again this august Middle East Strategy Forum to discuss the important issue of the unprecedented escalation of the conflict in that region. All of us know, or should I say all of us should know, that South Africa instituted contentious proceedings against the State of Israel at the International Court of Justice on the 29th of December 2023 in an application called the Application of the Convention of the Prevention and the Punishment of the Crime of Genocide in the Gaza Strip, in the case now known historically as South Africa versus Israel. Since then, South Africa has brought further applications in this matter to the court, and the objectives of these various applications are clear. And since then, Israel's war of aggression has spread to the wider region of the Middle East. Escalating conflict in that region is a reality that confronts us all. At one level, South Africa's application to prevent genocide against the Palestinian people, to hold those responsible for this genocide accountable for their actions, and to ensure the supply of humanitarian aid to the Palestinian people, the victims of this genocide. At another level, through its application, South Africa makes the important point that international law must matter. Accordingly, if international law is to matter, then it must be applied equally to all, without fear or favor. It would seem trite to state that if international law is to matter, then the institutions that are responsible to uphold the rule of law, on the one hand, must hold those accountable for their committing heinous crimes, and on the other hand, protect the rights of victims. It is my contention that Israel's refusal to abide by the requirements of international law threatens the very basis of international law itself. Without the system of international law, without the strenuous efforts to uphold the system, we surrendered the weak to the strong as lambs to the slaughter. We acquiesce to the barbarity of the powerful, to do with impunity to all of us in global society as they please. It would seem necessary that I deal upfront with some important issues as a result of the biased and negative narratives peddled as a way of devaluing the merits of South Africa's case before the ICJ. Firstly, South Africa submits that the action of the State of Israel in the Gaza Strip constitutes, under the articles of the Convention, the crime of genocide. In the fog of war, and in the context of the times we live in, reductive binary narratives often tend to obfuscate the understanding of issues. So let us measure in our mind's eye, knowing all that we know today, after witnessing all that we have witnessed to date, the meaning of the word genocide, and whether South Africa's charge against the State of Israel is credible. In terms of Article 2 of the Convention, genocide means, and I quote, any of the following acts committed with the intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. A, killing members of that group. B, causing serious bodily harm or mental harm to members of that group. C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D, imposing measures intended to prevent birth within the group. E, forcibly transferring children of the group to another group. We can all agree that this definition is startlingly unambiguous. The lived experience of the Palestinian people subjugated to this genocidal war is also unambiguous insofar as the scale of killing and destruction is concerned. Having regard to the countless victim testimonies given before the world, reinforced by what we see live streamed into our consciousness every single day since October 7th, it is hard not but to conclude that indeed South Africa's charge against the State of Israel with the crime of genocide is not only credible, but it is equally valid. Secondly, to support its charge, South Africa has submitted to the ICJ credible and irrefutable evidence that illuminates the applicability of the Convention to Israel as a contracting party to the Convention. Thirdly, South Africa's attempt to hold the State of Israel accountable for its action is neither anti-Semitic nor based on anti-Jewish racism. We reject this nonsense. Fourthly, Israel is a signatory to the Convention. Israel, by the articles of the Convention, has pledged that she is committed, either in times of peace or in the time of war, to prevent and to punish the crime of genocide. Fifthly, the articles of the Convention make no exception for the State of Israel. Accordingly, Israel has no special status in the Convention that allows it not to be held accountable for its violations. When South Africa instituted its contentious proceedings against Israel, many were surprised. Perhaps some were even wondering why South Africa and/or why the ICJ. South Africa is unvexed by the surprise and considers it completely misplaced. Against the backdrop of our own apartheid past, South Africa has had a long and checkered history with the ICJ. Allow me to recap some of this history. Many would be familiar with a series of cases litigated before the ICJ over 2 decades, from 1950 to 1971, concerning the once colony of Germany, the former Southwest Africa, now called Namibia. It is okay. You can take some notes. This is history now. In particular, I refer to the contentious proceedings from the mid-1960s, for example, the case of Southwest Africa, Ethiopia versus South Africa, Liberia versus South Africa of 1966. In addition, I refer to the request by the United Nations Security Council for an advisory in 1971 on the legal consequences of states on the continued presence of South Africa in Southwest Africa, notwithstanding the security resolutions on the international status of the then Southwest Africa. Unfortunately, the contentious proceedings initiated by Ethiopia and Liberia in the 1960s were dismissed on the grounds that the court at that time considered those 2 states have not established that they possessed any legal right or interest in the matter. However, in 1971, a differently constituted court charted a different course and rendered an opinion that the continued presence of apartheid South Africa in Southwest Africa, now called Namibia, was illegal, and that apartheid South Africa was under an obligation to withdraw its administration immediately. Mona, you owe me for this, getting me out of my sick bed. The court also found that the UN members were under obligation to recognize the illegality of apartheid South Africa's presence in Namibia and the invalidity of any acts in respect of Namibia. 19 years later, on the 21st of March 1990, Namibia finally gained independence. The Southwest Africa and Namibia cases are important for several reasons. They concern the right of a people to self-determination, to be free from foreign occupation. These cases are also relevant because they tell a story about the role, relevance, and the power of international law, and especially of the ICJ. International law commentators observe that this decision by the ICJ in 1966 in Ethiopia and Liberia cases was a blow to the credibility and the relevance of the court, having not risen to the occasion to come to the aid of a state and people under foreign control. The 1971 advisory opinion restored some confidence in the ICJ to some extent, but it was probably not until the case brought by Nicaragua against the United States in 1984, judgment was given in 1986, concerning the military and paramilitary activities in and against Nicaragua, when the ICJ's relevance was reaffirmed. In that case, the court found that the United States had violated the obligations imposed by customary international law not to intervene in the affairs of another state, not to use force against another state, not to infringe the sovereignty of another state. In 2004, South Africa participated in the advisory opinion proceeding concerning the legal consequences of the construction of a wall in occupied Palestine territory. In this case, the court found that, amongst others, the construction of the separation wall built by Israel in occupied Palestinian territory, including in and around East Jerusalem and its associated regime, was contrary to international law. The court further ruled that Israel must forthwith cease construction of the wall and immediately dismantle it and make reparations for all the damage caused by the wall's construction. Post-apartheid, or rather democratic South Africa, also participated in the advisory opinion proceeding concerning the legal consequences of the separation of the Chagos archipelago from Mauritius. The matter was brought before the court in 1965. In this matter, the court found in 2019 was the final verdict of the court, amongst others, that the process of the decolonization of Mauritius was not lawfully completed when that country acceded to independence in 1968, following the separation of the Chagos archipelago. The court further ruled that the United Kingdom is under an obligation to bring to an end its administration of Chagos archipelago as rapidly as possible. More recently, the General Assembly requested an advisory opinion from the ICJ on the legal consequences arising from the policies and the practices of Israel in the occupied Palestinian territory, including East Jerusalem. South Africa submitted a written statement in this case in July 2023, just a couple of months before Israel commenced with its genocidal war against the Palestinians in Gaza after the attacks of 7th October of 2023. South Africa's submission in that matter characterizes Israel's conduct as part of a continuum of illegal acts perpetrated against the Palestinian people since 1948 Nakba and since the 1967 occupation. On 19th October 2023, South Africa also referred the situation in the state of Palestine to the Office of the Prosecutor of the International Criminal Court, along with 4 other countries: Bangladesh, Bolivia, the Comoros, Djibouti, requesting the prosecutor to vigorously investigate crimes under the jurisdiction of that court. A clear and consistent theme is apparent. South Africa has been involved in the landmark cases of the ICJ that concern self-determination and the right to be free from foreign occupation. The Southwest Africa cases, the Wall case, the Chagos case, and the case of the legal consequences of the occupation all testify to that. We, as South Africans, whose lived experience has been shaped by centuries of apartheid, know precisely the lived reality of apartheid. We have lived apartheid and we have suffered apartheid. We know apartheid when we see apartheid. None dare contradict us in our assertion that Palestinians live their lives in an apartheid hell. It should therefore not be surprising that South Africa has initiated the most recent case under the Genocide Convention in an earnest effort to protect the Palestinian people whose right to self-determination has been infringed for decades. Could I ask someone to bring me some water, please? As South Africans, we have never forgotten that our own liberation from apartheid was a product of international solidarity. Thank you. In the realm of public opinion, apartheid as a policy was a pertinent question in the domestic political debates of many countries at that time, including here in Canada. Apartheid was discussed in international politics, in debates and resolutions of international organizations, from the Organization of African Unity to the Commonwealth to the United Nations. So too must it be in regard to Israel policies of apartheid against the Palestinian people. Apartheid featured in the making of international law. Example, the 1973 International Convention on the Suppression and the Punishment of the Crime of Apartheid, the 1998 Rome Statute on the International Criminal Court, which included apartheid in the ICC's jurisdiction as a crime against humanity, and in the litigation before international courts. So too must it be in the case of Israel policies of apartheid against the Palestinian people. It may have taken many years, but in the end, the international law norms that developed and were refined around the crime of apartheid led to the dismantling of the regime in South Africa. The dismantling of apartheid, but the resilient application of international law, contributed in very large part to South Africans gaining their freedom in 1994. Yet, as it was said by former President Nelson Mandela, South Africa's freedom shall remain incomplete until Palestine is free. More recently, on 3rd October 2024, 5 years after the ICJ opinion, it was announced that the United Kingdom and Mauritius have reached an agreement in terms which the UK will hand sovereignty of the Chagos archipelago over to Mauritius. It is important to remind ourselves of all the examples of progress that has been achieved since at least the establishment of the United Nations and the ICJ and its principal judicial organ. The importance of the proceeding currently underway before the ICJ and other international courts and tribunals, as well as the actions in the UN for that matter, reinforces the truism that international law matters. Furthermore, a clear trend of increasing relevance of international law can be discerned if one considers that with 23 pending cases on its list, the ICJ is busier than it has ever been in its history. In the case against Israel, South Africa has relied on erga omnes, obligations enshrined in the Genocide Convention, to request provisional measures. Erga omnes obligations are those obligations and international law that are owed to the international community as a whole. Even though the Palestinians are the direct victims of Israel's act of genocide, each party to the Genocide Convention has an interest and indeed a right, and here I must remind others, and indeed an important obligation to demand compliance from any other party to prevent and punish the crime of genocide. There's an obligation to all parties in the convention to ensure that they do everything to prevent genocide and to punish genocide. I'm going to remind Canada of its obligation. As a contracting party to the convention, I would argue that Canada is neglectful of its obligations. And by definition, by the very convention, may be complicit by its ignoring its obligation. There, you can go and P&G me now. The ICJ, in a groundbreaking judgment on 26 January 2024, recognized the Palestinians in Gaza as a group, as contemplated by the Convention, and issued several provisional measures to ensure their protection as a group. Israel must prevent acts of genocide and incitement to commit genocide. Israel must enable the provision of humanitarian aid. Israel must preserve evidence of atrocities, of crimes committed. Israel must cooperate fully with the United Nations and ensure the provision at scale of basic service and humanitarian aid. Israel must allow unimpeded access to the Gaza Strip of any commission of inquiry, fact-finding mission, or other investigative bodies. Subsequently, given the specific circumstances prevailing in Rafah, the court also ordered Israel to immediately halt its military offensive, which may inflict on the Palestinian groups in Gaza's condition of life that could bring about its physical destruction in whole or in part. Israel was also ordered to account to the court on its implementation of these provisional measures through reports submitted to that court. Have these court orders been complied with? Clearly not. Notwithstanding, other parties to the Convention cannot escape their obligations to the Convention. They have, at the very least, the legal obligation to demand compliance from Israel to the provisional measures and to demand that Israel prevents and punish genocide. Unfortunately, international law rarely yields quick results. This is mostly a function of the fact that the international legal order is a horizontal system. It is based in most instances on the consent of states, consent to be bound by substantive rules, and consent to be subjected to the jurisdiction of international courts or tribunals. In addition, we do not have a global police force that can enforce court rulings. It is for this reason that the institutions of global governance, especially the UN, must step in and take action. Yet, we cannot escape the burning and urgent question of our time. What must the international community do when a state, by its impunity, withholds its consent to be bound by international laws? The answer to this question requires us to address another important question. Do we have the willingness to act against such a state? Our desire for a better world order must mean we pay attention to these vexing questions, and we better pay attention to these vexing questions now. Each member of the international community has a role to play in the process by demanding action and compliance with legally binding orders of the ICJ and international law in general. States must play this role through their engagements at the international level and through their votes at the General Assembly and in the Security Council. Civil society also has a critical role to play to demand accountability from their governments. Let me repeat that. Civil society also has a critical role to play to demand accountability from their governments. Should I repeat it once more? International law is part of a larger ecosystem of global governance. The values that it seeks to advance should also be championed in the political realm. While the speed at which international law can bring about accountability or change may seem modest, in many, perhaps most cases, we dare not abandon hope. As it is often said, the wheels of the law turn slowly, but they do turn. I thank you very much for your attention.